Lord, may I have a little indulgence? In respect of item number 2, last evening I have received a request from the government to appear in this matter. But I have spoken to my.
But we are granted enough time.
But I need just a little accommodation just to be able to go through the
encroachments.
I have hurriedly gone through. We are also required to, I understand, we are also required to file an affidavit. That is also under process, almost ready. We'll be filing it very shortly. So Lordship will accommodate me for a week or 10 days. I have spoken to my learned friend, Mr. K. Chaudhary. He has kindly consented to it.
2 weeks.
Deeply.
Daily list for hearing. Item 1.
May I present it? In the last occasion, my lord, the respondent number 3 was directed to file the report of.
It was supplied to you.
Yes, my lord. Yes, my lord. So according to the report we have gone through, some measures they have taken against the substandard drugs which have already been declared. But here, since the PL was filed in 2018, since then it was reported number of drugs has been reported as misbranded and also substandard drugs. But for the sake of controlling of these substandard drugs, they have not taken any steps. Only after detection, they have taken steps for action against the suppliers. So we are, I'm submitting.
What mechanism you suggest that before
Yes, madam.
entering into the market or before throwing that material is available in the market, what measures they can take?
They have taken the measures. Actually, they have issued the show cause notice. And also
notices to the persons.
Yes, to the suppliers.
Yes.
Yes, my lord. And also some other measures also regarding penalties of delay in withdrawal of not of standard quality items, and also penalty for delay in replacement of not of standard quality medicines, and also penalty for non-supply of or non-replacement. These are the measures they have taken.
Then what you are suggesting that
My lord,
stop it?
Yes, my lord. My submission is, so if at the entry point when they have procured through tender or some other measures, if batch-wise, those medicines are tested.
The drugs are being purchased.
Yes, ma'am.
From the market.
Or not through tender process, my lord, not by market directly.
Oh, in the tender, they should have specified the quality of the drugs.
Yes, ma'am.
What they want.
The suppliers has to submit some testing report from the NABL laboratories. But in spite of that, they are supplying those NABL certificates. In spite of that, these type of substandard medicines are being detected. So that is why in the entry level, when they are procuring,
what you are suggesting that it's very
Lordship.
difficult to, because once they are if the government floats a tender
Yes,
and they're supplying the drugs, immediately they are required to be distributed. Can't
Yes,
we
ma'am.
stop for a long period that first they'll check the drugs and then suppose some batch or some material in the batch is going to be spurious or whatever it may be adulterated, then again they have to float a new tender for that.
Actually,
Then when the medicines will be available to the
there
public
is
at
a, if,
large?
according to section 26, if it is purchased and it can be tested. But if it is any measure, so that because after supplying the medicines, those are distributed to the consumers, and after consuming, and some of them are not consumed, but most of them are consumed. After then it
To
was
the public
detected,
at
my
large at free of cost.
lordship.
These drugs are supposed to be distributed to the public at large at free of
Yes,
cost.
yes, my lord. That is well. It is a government supplied medicine through NSA, my lord.
Response to the petition is filed on behalf of the state wherein the measures taken by the state for checking the menace of spurious drugs supplied by the supplied by the suppliers has been detailed of. Learned counsel appearing for the petitioner, if desired so, may file the counter affidavit to the reply filed on behalf of the state. This matter will be listed for, the matter is admitted, no need to issue notice as parties are already represented. List for the hearing in due course.
Obliged, obliged.
Item 4.
May please your lordship. Mr. Architect of Study is out of station, my lord. Better maybe taken up after next week, my lord. Next week.
Yeah.
Must progress.
Item 5 and 6.
The short point involved in this matter is this, my lord. It's a provident fund, my lord. For recovery, my lord, they have to issue a certificate to the certificate officer. As per the act, my lord, they can charge 15% interest.
15%
Interest. Now, my lord, as per the Bengal Public Demand Recovery Act, if you also see section 3(6), my lord.
Yes.
Section 3(6) says, my lord, public demand means any area of money mentioned or referred to in Schedule 1 includes any interest which may by law be chargeable thereon after their certificate is signed. So they have to issue the certificate along with the interest. That becomes the principal one. Section 3, subsection 6.
Demand
My lord.
means any area. Any.
Well, it becomes a decree virtually, my lord.
This part second,
Second, my lord, it is in the act.
filing of certificate for public demand payable to the collector. So what's the date of this certificate?
My lord, certificate is issued in 2007, my lord.
2007.
Yes.
We are at in the.
2009,
2009, I'm sorry, 2009, my lord.
34, 2009.
34, 2009, at page 39. 74, 75. 74.
ये कह रहे हैं यहाँ ऐसा कुछ
2000.
Any such certificate is issued?
My
or
lord,
not?
page 74 and 75.
74 and 75.
It's
Yes, 70. This is of 30th of April 2007.
9, my lord.
9. Okay.
Then, my lord, here, what happened after the certificate is issued, as per the Bengal Public Demand Recovery Act, section 16. My lord, the interest which is included in the certificate, that also becomes principal, my lord. So far the certificate is concerned. And now we have to pay interest at 6% as per the section 16. Six, my lord, you will also see there shall be recoverable in the proceeding, execution every certificate of file.
There shall be.
Interest after the public demand.
interest
Public
of
demand means, well, the principal plus interest,
six.
to which the certificate relates at the rate of 6.25% per annum from the date of signing of the certificate after date of relation.
They have charged 15%.
They wanted to charge even after the certificate is issued for 15%. But this cannot be done, my lord, because they have to include the interest and that becomes the principal. Till certificate is issued, my lord. That is the only point, my lord.
How
Just
the,
like a decree, my lord.
how the Leonard single judge attempt to.
Large as, my lord.
Page 89. Page 89.
89, but last portion, my lord, you will also. He has given reference to the interest act. Page 96, my lord, para 10.
Just
Ten onwards.
Mr. Sahiwala, where is the certificate? 74, 75?
Yes.
Who is authorized to issue certificate?
My lord,
Who can issue certificate?
The chairman
of
of chairman,
trustees,
chairman,
chairman, board
Chairman
of-
of the board.
chairman of the board of trustees.
Is there a provision in this act?
Well,
yes,
Where
yes,
is
yes. No, my lord, in the act it is there. Provident Fund Act, my lord, Assam Tea Plantation Provident Fund Act. I can give a copy of the, do of you? Please give it. Take copy. Section 15, my lord. As area of land level.
mode to recover money
Yes,
from the.
No, what we are asking is page 74 and 75.
yes.
The certificate issued by the chairman of board of, where is the provision in the law authorizing the chairman to issue the certificate?
Well, section 15 as a area of land revenue. Area of land revenue, my lord, that is the.
Which provision enables the chairman of the board of trustee to issue such certificate?
Well, chairman is the highest authority, my lord, of the board.
But there must be some provision under the law that this person, this authority is vested with the power to issue certificate.
No, that is not.
Hmm.
The chairman cannot issue. Chairman can issue a decree,
Okay.
like a decree.
Now, in the schedule, chairman is there.
Yes, there is a provision.
Well, the notification is there, it appears, my lord. That is apart to in section 74.
34.
Notification is there. Fourth para, the total amount of areas, so and so, I hereby
Section
order
24 of
74.
Page 70.
Page 70.
74.
74. The fourth para, my lord, is there. I have a order that in excess of power conferred by government notification number so and so. Under section 16 of the 14 note. Under section 15, my lord, some notification is there of the government authorizing the chairman to issue the.
Notification is there.
But
Under 16, the power of the government or in the. Mode of the. Sixteen of power to the. Chairman. Gap there, I don't know. Yeah, you did it. As your client paid the admitted amount,
Yes. my lord.
yes, it has been paid.
yes, some amount they have paid, my lord. Just I'm doing lordship attention to this on the document, my lord. There's a letter issued by us, my lord, to the company, my lord, that you will lordship will find that. Page 76, my lord. As per the letter, my lord, this total this interest was, my lord, amounting to rupees 3 crores 65 lakhs 7,080, my lord. And on receipt of this letter, my lord, along with this letter, we have annexed the statement of this how the interest is charged, my lord. The computation of the interest, my lord. Thereafter, my lord, on receipt of this letter, my lord, the appellant, my lord, filed letter dated dated, my lord. Page 84, my lord. They have admitted the amount, my lord. These things are, they have suppressed in their writ petition, my lord. They have not come with a clean hand, my lord. This was not a whisper, made any whisper regarding this Malay admission, and paid for allowing them to make the payment in installment, my lord. And thereafter, by the letter dated, my lord, 6/8/2016, page 86, my lord, we have allowed 50 installment, my lord. And against that, they have issued this purpose, they check also, my lord. In one hand, they have admitted, and the other hand, they have approached this honorable court, my lord, by suppressing this type of factual part, my lord, of the case. And that is also reflected in the judgment also, my lord, in paragraph 6, para 6 of this judgment, my lord.
Once you have admitted,
My lord, the only thing, my lord, I have not disputed the demand. I disputed only, my lord, the interest, my lord, after issuance of certificate.
Interest?
After issuance of the certificate. That is I am disputing,
after issuance of the
My lord.
certificate,
my lord. That is interpreted by Supreme Court also, my lord, just I am placing the 2-3 judgments of the Supreme Court.
but here this section 11
Yes.
of the Act of 1958 clearly
In the-
says that you have to pay 15% interest if you are not paid the
Yes.
within time. 30
In time,
days.
my lord.
Yes,
From the date
that's
of-
correct, my lord. That is why, my lord, the section 3(6) says that the demand when certificate is issued, it includes interest. So it becomes principal, my lord. Normally, my lord, interest is charged on the principal. My lord. So here, my lord, the interest also becomes principal when certificate is issued. But just I said, based on these judgments of the Supreme Court, my lord.
Yes.
The first judgment was 1967 year, that is para 2, my lord. A certificate is signed and filed under section 6 of the Bihar and Odisha Public Demand Recovery Act by the effect of a decree passed by the certificate officer, as such subject to provisions to act. Section 17A of the act provides that there shall be recoverable in the proceeding exists to every certificate filed under the act, interest upon the public demand, so which certificate relates at the rate of 6.25%, my lord, per annum from the date of signing of the certificate after date of realization. In view of section 17A, simple interest prescribed rate is payable on a principal amount of certificate and recoverable in the proceeding in execution thereof. It was suggested that argument the certificate holder has no right to claim interest unless assets are realized by sale or otherwise in execution certificate and are disposed of in accordance with section 32 of that. This suggestion is baseless. Section 32 lays down the mode of disposal in the proceeds of execution and the priorities to be observed in such disposal. Out of the proceeds, well, this is not necessary. So this is, well, lastly, it is written, my lord, in the letter of proceeding, certificate debtor cannot escape the liability to pay the accrued interest by paying the principal amount of the certificate. If any interest has been accrued due and is outstanding, the certificate debtor is entitled to realize by executing the certificate. So from the date of certificate, my lord, it is. The second judgment, my lord, 72-4 SCC, my lord, para 5, my lord. Procedure for enforcement of liability recoverable as an area of land revenue is prescribed in the Bihar, Odisha and Public Demand Recovery Act. Under section 4 of the Act, when the certificate officer is satisfied that any public demand is payable to the collector due, he must sign a certificate in the prescribed form stating that demand is due. The public demand by section 3.6 includes interest which may by law chargeable thereon up to the date the certificate is signed. This is the same language. Under part 2. So under schedule 1, item 3, the money which was declared by law for time being in force to be recoverable or realizable as an area of land revenue by the process authorized for the recovery of areas of revenue of the public or the public revenue or government revenue.
But your clients have not paid the certificate dues. It was issued long time back. You said 84 installments you will pay in 2016.
Well, the only thing, whatever amount they can realize, my question is, whatever today I think most of the amount has been paid. Now, the interest which it is charged after issuance certificate should be as per the Bengal Public Demand Recovery Act. That is the only question, my lord.
Yeah.
I'm not going to any other because the first order also stated that, my lord, when the case was admitted. Okay. Because only that portion has been stated.
Bengal Public Demand Act.
Yes.
Well, just matter of, just I draw your lordship attention to this letter, page 86, my lord, by which we have allowed the appellant for making payment of this, the amount, my lord, the certificate amount, my lord. In
Monthly installment.
50 installment instead of in place of 84, they have demanded, my lord, and pursuant to this letter, my lord, they have also furnished 20 post-dated check, my lord, which you will also will find at page 88, my lord.
88, yeah.
88.
They paid. They have submitted the checks.
Check, my lord, post-dated checks, my lord.
Okay.
Against that, we have realized up to serial number 12, my lord, that the procedure has been realized, my lord. The balance of that could not be because independent they obtain a stay order from this order report, my lord. In the appeal, my lord. Each appeal. No. Sorry, number. But just why I'm drawing, placing before also two letters, my lord, which we have received about the outstanding, total outstanding present, my lord. Have already. Please. Shall copy that? No, no. First letter is there at 3/10/2019, my lord. It is to me, and the next letter is 7/11/2023, my lord.
Yes. Order is up. Argument said already.
Bless you. Bless you.
Item number 7 to 15.
It's the Sai wala. Why there are two appeals for two different? Yes.
My lord, this matter relates to conversion of the of the petitioner from surveillance worker to lower division assistant and storekeeper. And later on, my lord, after utilizing their services for more than about 10, 15, 12 years as lower division assistant and storekeeper, they are reverted back by the impugn order and without any prior notice. And there is some, I will submit later. Now, my lord, there are three categories. These two persons, appellants, Pankaj Somua and Fotik Bora, they have jointly filed the writ application before the learned single judge because they are belonging to Lakhimpur district under the same malaria department. And because they have been aggrieved from the state order. And my lord, they had ultimately the appellant number 2, during the pendency of this appeal, he had been retired from service as lower division assistant. Now, appellant number 1, my lord. Now, Lord, you kindly see Annexure A1, page 65 to 66. My lord, his first appointment as surveillance worker on 27/7/2001
Page number?
as surveillance worker.
Page number?
Page, my lord, 65, my lord, 65. 65.
65.
65, my lord.
Yes.
My lord, in pursuance of government approval issued letter number dated so and so and subject to discharge without notice and assigning any reason thereof. Also subject to satisfactory PVR of Sri Pankaj Somua, son of late Devo Somua, son of ward number 3, Ponindo Road, North Lakhimpur, District Lakhimpur, is hereby appointed as W on compassionate ground as purely on temporary basis in the scale of pay of so and so. Other allowances as admissible under rules and places under the disposal of the Joint Director of Health Services, Lakhimpur, North Lakhimpur, for posting against the existing vacant post of surveillance worker in Lakhimpur district. My lord, he was initially appointed. There is no dispute regarding his first appointment as surveillance worker in the year of 2001.
Purely on temporary basis. Purely on temporary basis.
My lord, purely on temporary basis, but as per due procedure of law, he has been
Due
appointed
procedure of law.
as surveillance worker, and he has been continuously working for about 6 years till 3/11/2007.
Just a minute.
Yes, my lord.
So this surveillance or whatever the post may be, so there is any provision for recruitment of these surveillance workers?
This person is appointed on compassionate. I think I will ask them. I think the surveillance worker also came under some scheme. These are not. Because I think
Yes,
My lord, his appointment as compensation on compensated ground, it is as per due procedure of law. I have given the reply of the affidavit. It is clearly mentioned that how he has he was appointed on compensated ground.
Okay,
There is
then-
no dispute, my lord. I will come later on, my lord.
when you were asked to discharge the duties of LDC, there is that order. Later on, you were asked to discharge the duties of the LDC,
LD.
lower divisional clerk.
Oh, my lord, yes, I'm coming. Let's say second annexer A2, my lord, A2. That is, he is converted. Page 67, my lord. Page 67.
Page 67. Until further order.
But this is the conversion order, my lord. Page 62. Sorry, page 67. Page 67. Annexer A2. Until further order, Sri Pankaj Sharma, attached to the office of the BEMO Lakhimpur is hereby designated as LDA in the same office and in same scale of pay with effect from the date of joining as LDA against the vacant post in the interest of the public service.
Conditional certificate.
Yes,
Now, my lord, here he was converted on 3/11/2007. And similarly, appellant
Para
number
number?
2, my lord.
para number?
He
What
has
para you are referring? Which para you are referring? Which page?
67 page, my lord. 67.
67 is the yes.
Para 2. Para 2, my lord.
Read.
Para 2 of the read petition, my lord. Sorry, my lord, sorry. Page 58, my lord. Page 58.
Yes.
Page 58 of the read petition, my lord. Amendment on the paragraph 2.
Yes.
Yes, my lord. That your humble petitioner beg to state that the petitioner number 1 is initially engaged as surveillance worker under the office of the Joint Director, Lakhimpur, North Lakhimpur, Lakhimpur District on 27/7/2001. The service of the petitioner number 1 was designated as LDA from the post of surveillance worker in the same office by this office order memo number dated 3/11/2007. Thereafter, the petitioner number 1 is serving in the said post to the satisfaction of all concerned without blemish whatsoever. Copy of the appointment order is that your next, Your Honor, your humble petitioner begs to state that the petitioner number 2 is initially engaged as surveillance worker under the office of the district malaria officer Lakhimpur, North Lakhimpur on 26/2/1985. Thereafter, the petitioner number 2 was designated as storekeeper from the post of surveillance worker in the office of the district malaria office Lakhimpur North Lakhimpur by office order memo number dated 5/12/2006 and memo number dated 7/12/2006. His service was designated as LDA from the post of storekeeper in the same office. By this office order number dated 3/5/2014, issued by the Joint Director of Health Services, cum State Program Officer, MBBTC Assam, Istanbul Street, Guwahati 5, and he is serving in the same post to the satisfaction of all concerned without blemish whatsoever. My lord, these are the the appointments, both of them were appointed as surveillance worker and storekeeper, and as per due procedure of law. Now, my lord, suddenly, by annexer F, Lord say, I am coming to impugn order. 85. Lordship, kindly turn to page 88A. 88A, annexer F.
Yes,
My lord, my respectful submission before this honorable court. Now, whether this impugn order has got legal validity in the eye of law,
what is that?
that is to be decided by, yes, Sovereign.
Yes,
Yes, my lord. Your also can you see in persons of government letter number dated 13/8/2013, issued on the strength of the order dated 13/6/2013, passed in WBC number 1941/2013 and HLA 553/2013/82 dated 28/4/2014 by the Honorable Guwahati High Court. The following LD assistant working under the establishment as noted below against each incumbent whose original appointment were surveillance worker, basic health worker, and subsequently they were converted, transferred to the post of LDA, statistical assistant, storekeeper, are hereby withdrawn from the post of LD assistant, statistical assistant, storekeeper, and reverted back to the post of surveillance worker, basic health worker at the earliest as shown below. Now, my lord, here 9 persons have been reverted back. Now, your lordship, it is a very interesting point. I will come regarding in persons of the 2 letters arising out of the WPC 1941-2013. That is, their case has been preferred by one Biru Bhutto Asarji belonging to Silsor. That is different case law. And we are not concerned with that case law. But I will come later on. But here is a very serious discrimination on the part of the government regarding serial number 5, my lord. Serial number 5, Azhar Ali Ahmed. He was also initially appointed as surveillance worker. He was also, like us, converted to lower division assistant. But to the utter surprise of the petitioner, he was promoted to upper division assistant. From this list, without any modifying this order, without any, how they have, I have categorically stated in additional affidavit submitted before the Honorable Single Judge. Lordship, kindly turn to page number. Answer B1, page 69 to 70.
yes.
Uh, yes, you know. No, later. Lordship, I'm sorry. No, next time, 69 to 70. It's on television. But just kindly turn to page number, sorry, annexer 93, page number 93.
Yes,
Annexer A1. This is the promotional order, my lord. As per recommendation of promotion committee, subject to reversion without notice and assigning any reason thereof, the following LD assistant computer stenotypists are hereby allowed promotion temporarily to the post of upper division assistant in the scale of pay of rupees 14,000 so and so and get pay so and other allowances as admissible under the rules. Now, let's say kind in 94, page number 94. He's Fazar Ali Ahmed, serial number 40. And at present, he is working in Gwalpara as upper division assistant. Page number again. ठीक है
Sir, This argument which we are raising, that one of the person, this Fazal Ali Ahmed, has already been promoted as UDA, that has not been raised before the learned single judge.
My lord, it is before the honor, learned single that we have placed before this matter.
Is that such
My lord,
argument is there?
actually, what happened?
No such argument is there in the order itself.
My lord, my lord, we had raised the matter before the honor, learned single. But it was no, the honor single they did not mention about this anything. And it was he was promoted by Director of Health Service Family Welfare, and the impugned order was issued by the Director of Health Service of the Malaria Department.
Is he a party in this proceeding?
Pardon.
Oh, is he a
Oh,
party in this proceeding?
No, no.
Then we'll not go into
No,
that.
he was not in that party, but because it was later through RTI, Lordship, through RTI, we have got this information later on. And then immediately we have filed it through additional affidavit.
पहले तो इनको NPA में देना ही पड़ा।
This judgment is Virabrata Acharji, 1911-2019. Where is that copy of the judgment?
My lord, my lord,
1 minute.
yes.
Where is the judgment in Virabrata?
Yes, Lord. Paragraph 12 is very relevant here. Internal page 7.
Only for 6 months, he was appointed also the lower division assistant for spondylitis disease. But later on, his prayer was rejected, and then he preferred this WBC.
There are two judgments of the same petitioner. One initially, when he was not converted, then the Honorable Court in 2013 directed that it should be considered by the government and pass and speaking order. And the speaking order was challenged here.
But the 1941 case was disposed of with a direction to the respondent authority to give whether his prayer can be considered or not within 1 month. But after 2 months, government has informed that there is no existing rule, therefore his prayer cannot be considered. And that is, but there is nowhere mentioned regarding that our appointments are illegal. We are implemented as a necessary
No,
party.
it's not a question of illegal appointment. Your appointments were against posts created by under a scheme. You can't hold cadre posts, as simple as that. Who have retired from service? Which of the appellants have retired?
My lord, another 2 important points I have left it regarding promotional upper division assistant and page number 99, your lordship. Apart from Fazal Ali, already 2 persons were promoted to upper division assistant and they are allowed to go on retirement. Durgeshwar Soike and Mohendra Bora.
Two, three persons have been promoted to UDA.
So far as Procedural is concerned, there is a different director of health and family welfare. Director of health services, family welfare. It is a separate department. So how he went to the other department, we have to find it out. But not in the main department, director of health services. So we are all concerned about director of health services, not with the director of health services within bracket family welfare. If there is some illegality, we'll rectify it, Lord. It is not that for that he will get benefit.
What is wrong with the single judge's order? What is wrong with the judgment of learned single judge?
My lord, it is the same persons, they were also initially appointed as surveillance worker. And they are also converted to lower division assistant. After that, they were appointed.
Only this is your ground, the main ground, that since other persons were allowed to continue and they
My
were
lord,
promoted. Just
yes,
a
my lord.
minute, sir.
Regarding impugn order, they are
Just-
without any.
Let me complete, sir.
Yes, my lord.
Let me come. So this is the only ground that since some similarly situated persons were allowed to continue and were promoted, therefore you are also entitled to get the same relief. This is what your case is.
Yes, my lord.
So whether this post of whatever the surveillance worker or the health worker can at all be converted, or the persons can be treated equivalent to the post of LDA under the rules.
My lord, there is actually in the administrative perspective, yes, I'm coming. How they have, they have promoted.
This surveillance worker or health worker is a cadre post or ex-cadre post?
My lower division assistant, my lord, we are allowed to.
Sir, I'm asking for surveillance worker.
Yes, my lord.
Is it a ex-cadre post or cadre post?
My lord, it is a cadre post. Yes. It is a cadre post because, my lord, there were, before 2007, there was no
There is
rule.
your argument before the learned single judge that it's not a ex-cadre post, it's a cadre post. The learned single judge has clearly held that these are the ex-cadre posts.
Ex-cadre
Sanctioned under a
post.
scheme.
My lord, it is not ex-cadre post. That is wrong. Because, my lord.
Yes.
My lord, here I have submitted the two rules on notifications. Lordship kindly turn to in 8 January 2007, my lord. The first notification. Oh, yes, yes.
Yes.
My lord, in 8 January 2007, Lordship, pending finalization of a service rules to be framed in exercise of the powers conferred by the provisional to Article 309 of the Constitution of India, the Governor of Assam is pleased to make the following service order regulating the recruitment and the conditions of the service of the persons appointed as the paramedical and non-gazetted staff under the establishment of Director of Health Service as per implementation of National Vector-Borne Disease Control Program under the Vector-Borne Disease Control Program Worker Service. Now, my lord, appointing authority, Rule 2, appointing authority means Director of Health Service in respect to the cadre of Assam Vector-Borne Disease Control Program Worker Service. A board means the district selection board constituted for selection of surveillance worker and basic health worker and all other grade 3 posts for direct recruitment. And now, Lordship kindly say Rule 3.
So, sir,
Rule 3, page 2.
just a minute.
Yes, my lord, here.
The mode of method of recruitment as provided under Rule 5 and 6, that has been followed in your case or not?
Recruitment.
You were appointed after going through this procedure.
My lord, after 2007, those, our appointment before 2007.
So how can you claim that your appointment was under these rules?
But as per rule, they were appointed, converted. Because Director of Health Service and Lordship, it is a cadre post. It is categorically stated here that the service shall exist with following classes and cadres: surveillance worker and basic health worker.
Yes.
Now it is amended, my lord. It is amended subsequently. Lordship kindly, the second notification 29/2010.
Yes.
Yes.
Here also, rule 4, my lord, the appointing authority means the Director of Health Services Assam and the Director of Health Services FW. Now, member means, board means the selection board constituted under clause 2. Member means the member of malaria workers, including persons working as W, BSW, and all other grade 3 posts under the Director of Health Services Assam and Director of Health Services Family Welfare Assam. And number 6, my lord, rule. In the principal orders, in clause 6, for the heading first paragraph and subclause 1, the following shall be substituted, namely, direct recruitment to the cadres of SW. Here, just I want to draw you. It is the cadre of SW. This is not an ex-cadre post. That is my respectful submission regarding this rule.
Yes.
Now, my lord, in persons of the two letters arising out of WBC 1941, these two letters have got no relevancy with our case, because we are not included as the necessary party in the state laws. Nowhere mentioned regarding that our appointments were illegal. Therefore, my lord, again, another very important point, without any prior notice, suddenly you go, stand release order, you go to the field board. After utilizing my service for 10 years, 12 years, 8 years, you go to the field board. It is a malaria disease, very serious disease. Without any having experience. My service was utilized. I'm still working in Borpeta district and Golpur, Lakhimpur districts. I exercising my duties very sincerely, honestly in the official capacity. And during that, one MSc qualified I think to the employee was also appointed, because computer related works are very much necessary in the official work. And that's why they were one Ritu Munikolita. And later on, I'll come. My lord, these are the things, my lord, there are serious irregularities and illegalities on the part of the government. That after utilizing, if I would have, another very important point, I want to draw your attention of this honorable court. If I would have continued as surveillance worker, I would have got two promotions at this stage. And it is a promotional post now, my lord. Initially under the same pay school. But later on, my grade pay is increased, 6,200. Now, at present, I am drawing 6,200 after 7 pay commission. Now, surveillance worker 5,300. But in this case, there is no affidavit has been filed before the honorable single judge. And some other affidavits filed in other cases, but the affidavits which has been filed in other cases will cover the entire cases as the cause of action is the same. But no individual affidavit is filed before this case and in the next case, my lord.
Mr. Saikia, this, we are referring to this vector borne control program order. These are very casual and cavalier.
2007 Lordship. It was very casual
2010.
because
Not only casual, these are self-contradictory. Forget the
yes,
judgment of the single judge. Is this a rule prepared by the state authorities? You have a gradation list, there is no scope for promotion. Why do you want a gradation
there's a
list?
scope is promotional scope is
Where,
there.
where is it?
Where is that?
Yes.
Where are the cadres? Where are the different cadres?
Can I-
Schedule 1 mentions
Yes,
only
sir,
one.
I'll just place it, Lordship. Page 176. That is a part of the pay revision. There is item 8, page 176. In rate appeal 125. The whole channel is given there.
No, we are referring to this order of 2010,
Yes, Lordship.
vector borne disease control service order.
Service order 2006 and further amended as.
Yes, 2010 it was amended.
2010.
Yes. We have to read this along with the pay commission structure. That structure is at page 176 of the writ appeal 125. Page 177. Last at the bottom, surveillance worker. Next higher post is surveillance inspector,
Page 1.
177. Surveillance worker down below lot, last one. The next higher post is surveillance inspector. Then basic health worker, basic health inspector, senior inspector, the highest post in that category is district malaria officer. So they are in the district malaria officer.
That is the problem. ROP cannot create something which is
And
not.
I do understand, Lordship, there is absolutely correct, Lordship. There are two different structures, two different channels.
No, that's right.
Yes, sir.
Mr. Saikia, we are just pointing it out so that even.
Yes,
now
Lordship, in the
it
next,
is, these are generating unnecessary litigation.
absolutely.
The 2006 order speaks of a gradation list, but the only method of recruitment is direct recruitment. What is the logic behind this? Why do you need a gradation list? You can't promote anyone. Why do you need a gradation list for direct recruitment? And then you create a schedule 1, you put all this in the same class cadre. Only difference is there is a difference in pay scale. If there is only one cadre, where are you going to promote people to?
Surveillance inspector, basic health inspector, malaria inspector.
In 10 Lordship, page 167A, if you look at the category of definition of member in 2010 amendment,
Yes.
member means the member of malaria workers, including persons working as surveillance workers, basic health workers, surveillance inspector, basic health inspector, and malaria inspector. These are the posts. But categorically, how the promotion will take place. Regarding the selection, there are at 7 selection board. There are 2 different selection boards. But Lordship, what exactly is saying that where is the scope of promotion? That part is,
What we are saying is,
what are the
if
criteria?
you want to promote, make it clear, no, that
Very
these
clear.
are the cadres and these will be promotional posts. The matter is there. It's neither here nor there, and litigations come up different ways. These orders have been interpreted. Series of litigations.
Now we'll have to revisit the whole thing, Lordship.
What we have seen
Yeah.
in many other rules. These are all archaic. Somebody did it. Law has changed. The basis of these rules have changed. Then the courts are interpreting this in the light of the current principles, that the rule is a outdated principle. Then you have to follow this principle that legislative action, courts will not interfere, but rights are violated. So courts will look into violation of rights. Can these things not be streamlined? This will
Definitely,
automatically
Lord.
take care of large number of litigations.
In some areas, we have already entered into that domain, like engineering service and other work department. Here also we'll have to look into it. We'll do it.
Rules can solve this problem, very simple.
We'll simplify it, Lordship, and it's very categorical.
Yes. Can be done. What we mean to say, these are needless litigations. Departmental employees fighting one group against the other. This confusion was created because of the order which has named all these posts in one schedule.
No, it
Somebody
is,
misunderstood.
here it is very clear, Lordship. There are 2 different streams. Now, if they are coming here, they will stalling the promotional opportunities of the other cadre.
That is not the question. The question is how you ask them to appoint to work as a LDC for years together without there being any such provision.
That is why the rectification exercise we have done here.
What rectification exercise? Some of the persons were transferred to other departments. They were promoted, retired. Everything is there. What?
Right, because of the stay order. We have done it in 2016 itself. It is not today we are doing.
Even though a stay order was there regarding discontinuation of them from the post of this LDC, you have promoted them.
That may be a solitary case, not in every case.
2 cases though he has cited.
He has gone to the different department,
They are not parties.
but we have, they are not parties, number 1. Here we are 9, but we have rectified in 2 other exercises, Lordship. About another 20 persons we have done it. 11 and 9, 20 persons another we have done in 2015-16. And most of them have joined in the actual cadre.
They don't have any choice. Join karna hi padega.
Now, the thing is that it is not government, because of there are some influence, they have got these illegal orders. They have managed some officers and they have done it without government's knowledge at the directorate level or below that. When it has come to the government's notice, then the UP order was issued, and the 2 letters. 2 letters said not only revert them, find other persons and revert them also. It has come to the government's notice in 2013 when that Acharji's case came up. It is not that, Lordship, there are dark ships in every department. Because of that, these problems are being created. And if we look into go deep, we have already terminated more than 400 illegal appointees. In fact, some of them are also illegal appointees. Out of different departments.
Yes.
2 letters I would like to place, if my learned friends complete.
Now,
My lord, during the pendency of my learned, during the pendency of this appeal, my lord, and we had to file an additional affidavit because again, they have said that the rectification process was going on. Again, so many persons have been promoted. And that's why, and not only that, my lord, there are some other also grounds I have submitted. But you kindly, page number 131 to 152,
Yes,
that is the additional affidavit.
yes.
Now, through RTI application, my lord, we have got certain informations, and Lord, you kindly see page number 132, paragraph 3, my lord. That the deponent appellant begs to state that in connection with the present additional affidavit, the deponents have also returned and returned all the then the relevant information now one subclause 1 that the deponent begs to state that after informing the Honorable Guwahati High Court by the Deputy Secretary to the Government of Assam, Health and Family Welfare Department by the name of Srimati M. ACS. This is not relevant. Inform Anita Verma, Guwahati High Court and Standing Council Health Welfare. In absence of any provisions of conversion in service rules, this department regrets its inability to agree to the conversion from the post of surveillance worker to junior assistant. Then how? See, Durgeshwar Soikia already mentioned in paragraph number 4, page number 9 of the additional affidavit 14-14-17 of the instant of the appeal, bearing letter number that Mohendra Bora, bearing number that Lakhimpur, not Lakhimpur, have been promoted to UDA from the post of LDA, whose original appointments were also surveillance workers in the year 2014. 2014. Similarly, Mohammad Fazir Ali, already mentioned, promoted to UDA. The additional chief medical health officer, Gwalpara, in the year 2019, whose name was shown in serial number 5 of the imperial order dated 22-17 NSRF. Mohammad Tariquddin Ahmed, promoted to UDA accountant. This is the new person in the year of 2014 under the establishment of the district malaria office, Kamrup. Anita Diary, Gauri Ghosh, Utpal Muzumdar, Ashish Ghosh, and Bhupendas, Vibhuti Bhupendas. These are the persons, my lord. The deponent further begs to state that although they had preferred an RTI application to get the details of why the above mentioned similarly seated employees who were promoted to UDA but were not reverted back to the original post of LW, but the respondents remained silent without furnishing the said information and documents till today, which shows that there is a malified intention, arbitrariness, and discrimination on the part of the respondent authorities by suppressing the real fact. Now, my lord, next page, my lord, 134. It is pertinent to mention here that during the pendency of this read appeal, the respondent number 3 on 17-10-2022 promoted one Phanindra Das LDA, joint assistant under the establishment of Joint Director of Health Services, who was initially appointed as insect collector, was at first promoted to LDA and thereafter he was promoted to UDA on 17-10-2022. And similarly, some other employees also. But these are so many persons, they were promoted during the pendency of this read appeal. Now, my lord, here, my lord, during the pendency of this gradation list was also prepared regarding the present status of the LDA, the present appearance. Annexure 7A, my lord. This is the gradation list. They have also prepared. Here, all the appellants, my lord, the name of the appellants are here, my lord, about the length of service. It is categorically shown here. My lord, here, serial number 9, my lord, Pankaj Samua, LDA. His length of service, 13 years, 9 months. As on 39-2021. That means at present, about 12 years. Then, my lord, Abelul Haq, serial number 8. Serial number 8, his length of service more than 15 years, about 18 years. In this manner, gradation list also prepared, all the persons. Now, my lord, another important point, my lord, to consider that about 39, they are going to revert back to us to a surveillance worker about 39 posts of surveillance were abolished. These posts have been abolished. And in the Borpeta district, my lord, I am coming to for the next item, Manoj Das. While he was appointed, there are 18 persons were appointed. But in order to fill up the 18 persons, he was converted to lower division assistant. But there was no affidavit. They could not give any reply about that statement. I have categorically stated here regarding Manoj Das, my lord. And there are so many irregularities and illegalities. I'm sorry to learned Desi. He's coming. He's trying his level best to submit. But at this stage, my lord, in the event of reverting back, I will be, my lord, will be deprived to get any promotion because my juniors already promoted. And where to join, my lord? Because in Borpeta district, my lord, kindly see last annexer, annexer 9, my lord.
Yes,
Serial number 12, SW 39, number of sanction posts, number in position 39, and number of vacant posts 0. Now, I have been continuously working in Borpeta, my lord, because I cannot claim that I may be.
Mr. Sharma, conclude now. You have argued. Please conclude now.
Yes. Yes, my lord. Yes, I'll complete my. My lord, that's the only point regarding grade pay. Grade pay at present, lower division being the lower division assistant, we are drawing 6,200. And now surveillance worker 5,600. Now in the event of reverting back, that my grade pay will be decreased after working 10 years, 15 years. And here I have mentioned here.
Cancellation order, cancellation order. Cancellation order. This can be.
My lord, now I will not make it lengthy. Regarding it is a now promotional post, my lord. I had cited 2 case laws. One first Himadris case law, that is I have Himadris case law, that is our Guwahati High Court decision without any prior notice. My lord, this case law is here. This is from masteral worker to the reversion to original post as masteral workers from Thalasi, wherein the services of the petitioners were regularized. Petitioners working as masteral workers since 10/12/1990 regularized as Thalasi with effect from 22/7/2005, pursuant to direction of this court, as well as in terms of government policy for regularization of order, cancelling the regularization order and reverting the petitioners to their original post as masteral workers. No so-called notice or opportunity of hearing order passed by this court about the appointment of the petitioner, since not considered. Now this is considered basic minimum requirements of the principles of national justice not considered. All relevant factors before arriving at the decision adversely affecting the right of the petitioner, not taking impugn order set aside, liberty to take action after consideration order ordinary. Here, my lord, they were appointed to Khalasi, regularized, then suddenly they were reverted back without any prior notice. Similarly, our matter is also same.
yes,
My lord, second case law, promotional matter, promotion case, Balbir Singh's case, my lord.
yes.
It is a appeals decision. It is a covered case, my lord. Now here, the, may I read my note? Promotion, erroneous promotion, as to pen. Now here, once government had supported appellant's promotion before court of law, it could not revert him on this ground that promotion was erroneous. Appellant promoted as a ST candidate, another employee filing writ petition against this promotion, government contesting the writ petition on the ground that appellant being a ST candidate was entitled to promotion under relevant recruitment rules in view of affidavit in reply filed by the government, writ petition dismissed on 28/1988. However, on 2/7/1988, appellant reverted on the ground that his promotion was erroneous because benefit of reservation was not available on promotion. Hell, government could not be permitted to take self-contradictory stand on appellant's promotion. In the peculiar circumstances of the case, reversion order is set aside. Then in this case law, my lord, almost similar to our case law, but this is not interpreted by the honorable single judge in detail. But my respectful submission, other case law also dear my lord, but this is the two case laws on the basis of my respectful submission. This must have read.
Yes,
So my humble submission is there is a mixture of conversion, promotion, etc. There is a total mixture of the service jurisprudence, what I have understood now.
who is
Our case is very
responsible-
clear.
Who is responsible for this?
We are not responsible straight.
You are only responsible.
Lordship will kindly see.
Only responsible.
Lordship may hold that. I have no objection to that. But the thing is that we have, what is our submission before the learned single judge? Lordship will kindly come to the impugned judgment. Somebody took some undue advantage of some scrupulous or unscrupulous officers or the departmental health. For that, the whole government cannot take the blame. And when we have come to know, we have rectified it. It is a rectification exercise. And there is no question of transfer or promotion or of that like or demotion. It is purely a case of giving them the right position. We are not taking away any of their legal rights. Paragraph 14 of the judgment. What is our submission? Impugned judgment. No legal right has been violated here. Internal page, Lordship, page 140. What is our stand before the land? 149. Lordship may kindly take this. Writ appeal 125. Paragraph 18. May I read it, Lordship?
Yes,
The learned standing council health department submits at the outset that though affidavit in opposition has not been filed in all cases, those filed would cover the other cases as well. The learned standing council submits that it is the direction of this court which forms the basis of the decision to repose the petitioners as surveillance workers, basic health workers. He clarifies that the expression reversion has to be understood in the facts and circumstances of the case, wherein there is no change in the scale of pay and other service benefits. We are protecting everything, including seniority. And the learned single judge also done the same thing. And therefore, by such reversion, no legal rights of the petitioner has been adversely affected. That being the position, aspect of following the principle of naturalism has become redundant. Sri Gogoi elaborates that it is only when an adverse action is taken against an incumbent, the aspect of following the principle of natural justice would come in, and the instant case, no adverse action has been taken against the petitioner. What we are doing, Lordship, they have to work in the field. Somehow they manage the officers and started working in the office. Their whole entry into the service is for the purpose of management of malaria at the field level. For various pretexts, by influencing various persons, they somehow manage to come as the post of storekeepers, LDA, or upper division clerk, whatever way. They want office work and they do not want to go to the field. That is the core of the issue. When it has come to the notice of the Honorable Court, and when there is a direction of this Honorable Court that do the corrective measures, we started the process. Therefore, these two letters are very important. Two letters, Lordship will find at page 98. When Birobhata Acharji wanted, when his conversion was rejected. Then he came before the learned single judge for the first instance. That is the first case, 1941 of 2013. I am directed to refer to the Honorable High Court's order dated 13/6/2013, passed in so and so, and to inform you that in absence of any provisions of conversion in service rules, this department regrets its inability to agree to the conversion from the post of surveillance worker to junior assistant.
पहले वाला पहले वाला
Page 98, Lordship.
where is the order in 1941 of
That
2003?
order, Lordship, I will place.
Page number?
That order is at page 80. May I read this order? Page 80.
Page?
80. It starts at page 79. Birobata Acharya versus State of Assam. May I read this order?
Yes.
On 9/4/2000, this court passed the following order. Petitioner is serving as surveillance worker in Karimganj district under the National Vector-Borne Disease Control and carried on by the Health Department of Assam. Because of health reasons, the petitioner sought for conversion of his engagement from surveillance worker to junior assistant. Petitioner was subject to medical examination and thereafter his prayer was allowed, but for a limited period. As petitioner's health condition has not improved to enable him to discharge duties as surveillance worker, he has again submitted representation for continuation of his engagement as junior assistant by way of conversion of service. Here, in the last line, in a view of above, the petition is disposed of by directing the respondent to take a final decision in the matter within a period of 1 month. So whether we would like to allow him or not, that is the direction. While exercising this, we found that not only Birobata, there are a lot of other situations. And therefore, page 98. 13th August 2013, first communication from the Deputy Secretary to Birobata. I am directed to refer to the Honorable High Court's order dated 13/6/2013, passed in WPC so and so, and to inform you that in absence of any provisions of conversion in service rules, this department regrets its inability to agree to the conversion from the post of surveillance worker to junior assistant. So that particular petitioner was informed. Thereafter, Lordship, another communication was issued by the government at page 99. 28 August, April 2014. So the Deputy Secretary to the Government of Assam Health and Family Welfare Department issued to the Director of Health Services Assam. With reference to this department later on subject cited above, I am directed to say that the government has already regrets its inability to agree to conversion from the post of surveillance worker to junior assistant in respect of Birobata Acharya, surveillance worker, Girisganj, PHE. In spite of clear instructions from the government, you have placed Sri Birobata Acharya, surveillance worker as LD assistant under the disposal of District Malaria Office, Karimganj, order dated 23/10/2013, which is illegal and unauthorized. You are therefore directed to cancel the order issued in respect of Birobata Acharya SW, along with such illegal unauthorized orders immediately and communicate it to all concerns to take steps accordingly. Also, necessary disciplinary action may be initiated against the erring officials for such illegal act. So not only Birobati, we said that cancel all such illegal unauthorized orders. So government was very strict from the day one when it has come to the knowledge of the government. Thereafter, the first order was issued, which is impugning the writ petitions at page 84. In pursuance of government letter dated 13/8/2013 issued on the strength of the order dated 13/6/2013 passed in WPC so and so, and HLA letter dated 28/4/2004 by the Honorable Guwahati High Court, the following LD assistants working in the establishment as noted below against each incumbent whose original appointments were surveillance workers and subsequently they were converted, transferred to the post of LDA, are hereby withdrawn from the post of LD assistant and reverted back to the post of surveillance worker at the earliest as shown below. So 11 persons here. Then in our affidavit, we have mentioned at page Yes, page 96, paragraph 12 of the affidavit. Apart from this 9, what we have done, paragraph 11, paragraph 12, the deponent begs to deny that the order dated 13/11/2016 has been issued by taking a cryptic decision to revert the petitioner to his original post of surveillance worker. It is reiterated and reaffirmed that the order was passed to revert the writ petitioner along with similarly situated persons to their original post of surveillance worker as they were earlier converted to the post of LDA without following any norms, regulations, and in violation of the provisions of law. In this regard, it is also stated that by the order dated 30/11/2016, altogether 11 persons, including the writ petitioner, have been reverted to the substantive post, and out of them, 5 incumbents have already been joined in the so-and-so. They are Ruptomal Kakoti, Amitav Bora, etc., on all these dates. Then there is another order where additional persons were also reverted. So what we are doing when it has come to our knowledge, we started the rectification exercise, and that has been admitted by the learned single judge in the judgment. Observed in our affidavit what we have stated. We do agree there was fault on the part of some of the officials of the government. But when it has come to the knowledge, everything cannot be honky-dory all the time. So when there is illegal appointments, we have terminated more than 400 persons of the health department. In fact, some of them would also fall into that category of 400, but they were not touched because of the pendency of the case. If Lordship looks at their original appointment, few of the appointees were appointed for 90 days only. These seasonal workers, actually malaria control is a scheme for which 180 days is the maximum period in a year a person can work. So for 30 days, some entered, then another 30 days. That way, somehow, because of some unscrupulous officials in our department, they tried and got the opportunity of regularizing their services. That happened in 2001, 2, and 3. All these things happen. If Lordship looks at the legacy of our litigation, we have thousands of cases where illegal teachers, if there is a post of 40, 400s were appointed excess teachers, that we have almost cleared it. In health department, one big nexus was that I think there are some of them also. What they have went and joined in Dibrugarh or Jorhat on transfer, saying that they were transferred from Kokrajhar, but they were never appointed in Kokrajhar. With a transfer order, they joined in some offices and all the officials were put behind bar. It is not that we are sitting idle. All those persons were, those cases are also coming up in a day or two, the appeals, because before the learned single judge, the state government got a good order, uphold our termination. All these people, and huge numbers, not single digit or double digit. These are all between 400 to 800, that kind of persons in health department. And these persons, Lordship, they got this benefit without any norms. They are in the service role. And as a result, what is happening?
Yes.
So now our affidavit, what exactly we have taken the stand? Paragraph 4, paragraph 6, page 93.
Mr. Saikia, we have understood your point.
Yes, Lordship. In fact, there is no promotion and we are protecting their salary, all seniority. In the learned single judge also said the same thing in the last paragraph, Lordship. No personal right has been violated. They have to work in the field instead of the office. And they will get the promotions as per their channel, not interrupting or interfering in the another channel. Only that last line of the learned single judge's order.
Yes, we have seen it.
Yes, Lordship, then fine.
But I can 8 and 9 because I am repairing me. Possible kindly hear me.
Probably 8 and 9.
Because my facts are different. My lord will kindly take up read appeal 125/2021. 125, yes, sir.
Yes.
My lord, your lordship will kindly come.
Mr.
Page,
Das, what is your submission? We have already, this is a.
look,
these are-
factually, my case is different, my lord.
What is it? Please
Yes,
start.
You were not
My lord-
surveillance worker?
yes, the petition, the appellant before your lordships, he was initially appointed as surveillance worker on temporary basis. Thereafter, he was regularized. He was regularized
Regularized on the post of
surveillance worker.
fine.
Then, my lord, he submitted an application for his transfer of cadre to LD assistant.
Okay. Under which provision?
Sorry, my lord.
Under which
Milord,
provision of the law?
My lord, no service rule or recruitment rule contain any provision. This was a policy decision or administrative decision of the government.
What is
Milord,
that decision?
My lord, I'll just place. I'll just place the documents, my lord, that question will be answered because when I submitted the application, the director, the joint secretary written to the director asking that this person has submitted application for his transfer of cadre, whether there will be any inconvenience or administrative inconvenience or not. My lord, that is what record says, my lord. I cannot go
No,
beyond.
but PK, inconvenience, there's no question of any
Then-
inconvenience.
I'll just take
If
your
a
lordship.
person is appointed in an office to do some other work, what's the inconvenience to the officer, where the person is being sent? Which procedure, which provision of the law allows a person to convert this post of surveillance
These
worker or
are-
transfer his services from one department to another department, which is that provision?
These are, Miller, in the recruitment rule, Miller Lordship will not find any recruitment rule will contain a provision that a person from another cadre will come, a cadre from, say for example, SW will come to the Miller LDA, cadre of LDA. The recruitment rule will not contain that provision.
Then how you are supporting that?
I'll just take your lordship to the papers, Miller. My lord will kindly come to page 61, my lord.
Yes.
Page 61.
Yes.
This was the letter written by the Director of Health Services to the Secretary to the Government of Assam.
Fine.
Transfer of cadre from BHW to LD assistant thereof. In forwarding herewith an application in original along with its enclosures received from Sri So-and-so BHW under the control of Joint Director of Health Services Kamrup Panbadar Guwahati and say that Sri So-and-so has been working as BHW, prayed for transfer from the post of BHW to LD assistant under the entomologist cum research officer F. Guwahati against the vacant post there. The scale of pay of BHW and LDA of district cadre is also same. In this connection, the Honorable Minister of Health and Family Welfare has also recommended the transfer after approval of the government. In view of above, it is therefore requested that the government may please to communicate their approval in this regard at an early date.
Where is the requirement of the approval of the government?
Transfer of cadre, Miller, the approval is required, Miller.
Which provision, sir? Which provision of law?
Miller, it's a, if not, Miller, what happens?
Yes, there must be some provision.
There has to be a,
Transfer a person from one cadre to
this was
another
a
cadre.
policy decision of the government in
So
my
whether
respectful
that,
submission.
Whether that policy decision of the government is
It will, Lordship will not find in any
is applied-
recruitment rule.
then
This was a, Milord, this was a policy decision taken by the government that
which
this
is
was,
that policy? Where is that policy that one person from one cadre to another cadre? Show us the policy. Is there any policy?
this has to be a decision on the part of the government.
Where is
Otherwise,
that?
how
Where
can
is
I
that?
go on my
That
own?
is what the strength of the government. that
Lordship will
all
kindly
these-
come to
All
the,
these transfers are illegal. They have not come with that. There is a policy of the state and that policy was there at that time.
Milord, after 15 years of service, Milord, I'll just, Milord, let me place the papers. Milord.
So you mean to say that whatever they have done illegally or without there being any provision of the law, since 15 years have passed, that could be
I'm not on that,
that
Milord.
is to be treated as legitimized.
I'm not on that, Milord.
That is what.
my lord, I approached the honorable single judge saying that without any notice, without any procedure following, my lord, an order was passed in a writ petition, Birobrata Asaji saying that consider his case. That case was rejected in the year 2013.
Certainly you have a point that
That
without,
case was, my lord,
without following the due procedure of law, they have kind of reverted back to you that surveillance worker.
no,
First of all, you just satisfy us that they have transferred your services by following the procedure of law. Yes.
no, no procedure was followed. That's what I'm submitting. In Birobrata Asaji's case, this honorable court single judge passed an order that consider his case. The respondents, my lord, they rejected his case saying that this is not a fit case wherein we can include that person.
Not fit case, there is no
No provision. Yes, my lord. Fine. There was no provision. So that decision came in the year 2013. Thereafter, in the year 2016, relying on that 2000 order, they have, my lord, sent us these petitioners, they have sent us back. So in the meantime, my lord, in the LDA cadre, my lord, there is a seniority list published wherein we were assigned seniority. My lord, our pay has been changed, my lord. The pay of LDA, the grade pay of LDA is different to the grade pay of surveillance workers.
This is
Third.
but at the time of transfer, they said that the same scale.
No, the ROP rule 2006, my lord, the 17 came into effect from 1/4/2016. And the impugn order is of, my lord, 30/11/2016.
Mr. Das,
I'm sorry, my lord.
when was your client initially appointed?
As a surveillance worker.
Yes.
He was initially appointed as a surveillance worker on 9/12/1998.
Okay.
Temporary.
When was he made regular?
He was regularized on 29/8/2002.
Okay, at that time, which was the service rule?
Service rule is that, my lord, Assam Vector Borne Disease Control Program. At that point of time, no service rule was
Alright.
there.
So I will just, for your benefit,
Yes,
for
my lord.
future purposes, we'll just point out some fundamental flaws on your argument. Question of regularization will arise only when some rules create posts which are sanctioned by the budget department, and there is a recruitment made against those regular vacancies, either before the vacancies were available, but by following the due process of law. So first of all, there was no regularization of the service of your client in the year 2002, because on that day, these were not cadre posts. Unless there are cadre posts, there cannot be any regularization. Number one, these appointments are made against posts available under a scheme for a specific duration, because it was a malaria control program. And these are not supposed to be cadre posts. First of all right. Second thing, every service is created by a set of rules. The LDA post is a part of a service which is created by the health department rules. Your client was appointed against a scheme which ultimately there was an order of 2006 which recognized these posts. But there is no manner of absorbing an employee from one service to another except by the following process. Either there has to be a deputation and absorption, correct? And if deputation and absorption takes place, there is a procedure followed under the fundamental rules. If that is not followed, this entire process is illegal, even if it happens with the approval of the chief minister. The court cannot give a stamp of approval to such a process. Today, you are confronted with a situation where the learned single judge has held that the process is illegal. You are asking us to say that the learned single judge was wrong. How are we as division bench supposed to say that? Learned single judge has taken a view that the entire process is wrong. It could not have been done, which is correct. It could not have been done. So a wrong process, whatever benefit you got, you have to shut your eyes, forget it, and settle down to what is the reality. Beyond that, if you have anything to argue, you argue, but we will have to write out a judgment as per the settled principles of service law jurisprudence. These arguments that my client was regularized, these that have got no meaning. question of regularization does not arise. These posts were not cadre posts created by the government and the date on which your client was appointed. He could not have been regularized. So likewise, at every stage, we can point out things which will make your argument totally untenable. That is the problem with this proceeding. My lord has already pointed out
I'm sorry,
that
my lord.
this
at that
happened
time.
out of some process which you don't want to comment. Could be deliberate, could be a mistake, could be some pressure from somewhere. But you could not have migrated from one service to another in this process because it is simply not admitted under the service law jurisprudence. Even if there is a cabinet decision to that effect, if it is questioned, it will be open to judicial review. And here the government has rectified this defect. The learned single judge has found it to be correct. Where is the scope for the division bench to take a different view? You have to show that you have a fundamental right which accrued to you under the law, which you want to enforce in this proceeding. You can't show that. You had no right to be migrated from one service to another. It was a mistake. The government is saying it is a mistake. And it was a mistake because it is not permissible under service law jurisprudence. You could have been absorbed. You could have sent on deputation. But then you have to follow the provisions of FR 22. That has not been done. One stroke of pen, so people are shifting from this service to that service. Absolutely not permissible. That's the end of the matter. The government can approve a procedure which is recognized by law. Government is also bound by law. Courts are bound by law. Everybody is bound by law. If the government does something which is illegal, we set it aside. So the cabinet cannot approve something which is not permissible. Cabinet decisions have been interfered by the court.
Absolutely correct.
So merely because somebody took that decision, you can't pass on by saying that this is a policy decision. These are not policy decisions. Even if these are illegal. That's your case. That's where you stand. That's why no matter how much you argue, you cannot get out of this. The fundamental problem is this.
The government regularized, my lord, then government come up with
You
a stand.
can't. It was not regularized.
Still you are.
Yes, my lord.
You may
So I am
call it
saying,
regularization, but it
my lord,
cannot be termed as regulation.
if I ask myself, my lord,
Yes.
I just ask myself one question, my lord. Assuming yes, there were no procedure followed in my lord regularization. I'm not going into regularization because it's not a case that wherein my termination is ensued or it's a case wherein my conversion has been questioned by the government, my lord. So regularization, I'm not going, my lord. My conversion, so far as my conversion is concerned, assuming there is some irregularity, my lord. Assuming, yes, my lord.
Irregularity, illegality.
Fine, my lord.
It's not illegal.
Assuming there is some illegality, my lord.
Everything is illegal here. What do you mean by some? Absolutely illegal.
My lord, the argument that the learned AG has.
And this is, I want to interpret. In the administrative perspective and in the public interest, they have admitted. When it was through RTI, they have replied. Our conversation was done. And that's why, my lord, we are allowed to continue.
Your conversation
Now,
was
in the-
done,
in
no
the
doubt
rewarding
in the
the-
administrative
the-
interest,
the-
in the
the-
public
the-
interest,
the-
but without there being any such procedure laid down under the law. That is what the situation is.
What fundamental rule will be applicable?
Which fundamental?
Fundamental rule, generally rule 15 of the fundamental rule, whenever a person is appointed, he can be transferred to another post. There is a rule, whenever there is no rule, under Article 309.
Right, all right, Mr. Sharma, you have finished now.
Oh, sorry.
Yes.
That's what I-
Mr. Das, have you
Yes.
understood the point?
Lord, I have
If
got
you
your
understood,
point.
that's enough.
I am on a different, slightly different point, my lord. I am on procedural also. My lord, the learned single judge, my lord, derived conclusion that no notice, nothing is required. After 20 years, the government found that 20 years back, some illegality has happened. So, no notice, no procedure is required to be followed. The learned judgment of Honorable Single Judge in Biroproto Asajis came in, order came in 2013. 13 to 16, nothing was done. 16, somehow the government woke up and stressed all. In the meantime, the status of these persons has changed. we came here by virtue of bottom seniority, my lord. We came from SW to LDA by virtue of bottom seniority,
Protect kar diya order.
and by
Yes.
virtue of bottom seniority, and our seniority has been fixed in the cadre of LDA. We have been incorporated in the seniority list, my lord. Now, as on date,
ठीक है, all right,
I'm sorry.
yes.
I'm sorry. Now, as on date, the grade P of a LDA and the SW is different.
All right.
As the SW grade P is lower. So the Honorable Single Judge had come to a conclusion that there is no civil consequences. But perhaps with all due respect, my lord, there are civil consequences because a submission was made by the respondent that both are same. So that is factually incorrect, my lord. And second one argument was made that we don't belong to a cadre. We are under a scheme. But after our regularization, 2006 service order came and the SW and BHW are sanctioned posts. But the Honorable Single Judge has held that these are not sanctioned posts, my lord.
Yes,
These are not sanctioned posts, my lord.
yes.
So that was the conclusion derived by the Honorable Single Judge, my lord. If you want to revert us, my lord, at least we are entitled to a notice, my lord. The minimum requirement of law. After 3 years, you are sending us back without any notice, nothing, my lord. That too, in Virabhadra Asaji's case, we were not party, my lord. We were not party, and there was no direction that sent all the officers.
We have.
Fine, my lord, fine. I'll not repeat, my lord. Also will kindly consider.
Order is there. Arguments are order.
Highly obliged.
For hearing, item 16.
Deeply approached.
Council is on late.
Okay. Adjourn.
Item 17.
Same minute, same.
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 Adjourn. Single bench.
May I have a lordship? One of the judgment, which we are praying for reviewing, in my lord, your lordship will find at page 187. my lord.
Yes.
One of basic issue was regarding one contract regarding carrying of goods, my lord, by FCI. May I read, my lord? Page 189 starts, instant intercourt appeal is preferred by the Appearance Court Corporation of India for asserting the judgment. So and so passes on single judge, accepting the writ petition of so and so preferred by the writ petitioner with the following direction to the appearance hearing. For the reasons stated above, the writ court succeeds and in hereby allows the writ petition is disposed of with a direction upon the respondent 1, 2, 3 to release the balance payment to the petitioner in respect of additional 52.5 kilometers at the rate of so and so within a period of 60 days from the date of receipt of certified copy of the order. The respondent will also ensure that security deposit of petitioner is released along with payments and directed by this court. So, not this direction was not, that judgment was of the learned single judge was challenged before this honorable court. Now, my lord, the learned single judge, my lord, this court, my lord, I'm not coming to the other point, my lord, your lordship will kindly come to page 192, my lord.
Internal page of the judgment,
My lord,
192 of
well, that same judgment, my lord, I'm just referring to.
division bench judgment,
Yes, ma'am.
Division bench judgment.
internal page,
Internal page, my lord, it will be 5.
5.
And my lord, the conjugate year number is 192.
Yes. It is an admitted motion.
My lord, Para 7 I'm reading, my lord.
Yes,
With the submissions were recorded, Mr. K. Agarwal and a senior counsel assisted by so-and-so vehemently contended that the controversy involved in the instant writ appeal is squarely covered by the decision rendered in case of unobtained transport privilege. Thus, the learned single judge was not justified in accepting the writ petition. Per contra, Mr. Deka, learned counsel representing the respondent, urged the division bench judgment in the case of any trade in transport arising out of the very same NIT in which the respondent was awarded transport contract. Transportation work for one section. The FCI has accepted the judgment of the learned single judge passed in so-and-so in the said case after rejection of the appeal by the division bench, and in a consequence, payment has been made to the contractor concerned. Thus, as per Mr. Deka, the FCI authority are not entitled to adopt a different approach in the matter of respondent hearing. He further submitted the judgment of so-and-so relied upon by the FCI is distinguishable on the facts because in the said case, the claim of the contractor for payment towards extra mileage was not outrightly denied. Rather, the contractor was relegated to approach the Grievance redressal committee for ventilating its grievance. He urged that in the present case, the respondent contractor has already approached the Grievance redressal committee way back in the year 2018, but no decision has been taken on the said application. Well, this submission, well, the 2018.
essentially, you are seeking review on this ground only. Okay, in fact, in the year 2018, he has not approached the grievance redressal committee and he has simply sent a WhatsApp in the year
No, my lord.
2021.
Yes, my lord.
This is what your case is.
Well, basically, my lord, it was 2021.
Yeah,
The my lord WhatsApp was sent by the council.
yes.
After receiving the copy, my lord, that is pending. What is the outcome of that? To know that. That was sent. So, my lord, that after getting that, my lord, they proceeded into the matter.
Yeah,
Now, my lord, a notice was given to them. My lord, that was not, my lord, annexed with the any of the affidavit in opposition on the writ petition, my lord.
fine.
That fact has been, my lord, now discovered that a notice has been given that you come and appear before the Grievance redressal
When
committee.
this notice was given.
They said that, my lord, since the matter is pending before the Honorable High Court, it will not be proper on our part to appear. So kindly keep it in abeyance. That is the position.
Okay, redressal, this grievance redressal committee, suppose if he has not approached the grievance redressal committee, despite that, what's wrong in this judgment in the learned single judge or of the division bench?
My lord, your lordship will kindly see paragraph 12 is creating little problem. Paragraph
195.
195.
Yes,
Yeah. Furthermore, page 195, furthermore, the Grievance redressal committee to whom the respondent petition moved for ventilation is Grievance, raising claim for payment of excess distance has not decided the claim even after a period of 5 years.
okay, that's.
My lord, you kindly consider that aspect of the matter, my lord.
The judgment
My lord, it
ultimately.
ultimately reflects on what, my lord, I'm basically on that, my lord. The department is, my lord, whatever decision the division bench has given.
In one case, you have granted relief to one party and in the case of the present respondent, you are denying him. This is what the basis of the
My lord,
judgment.
my only
These
grievance
are the only observations, okay, even
My
though.
lord, we kindly consider one aspect of the matter only, my lord.
Yeah.
My lord, our contention was that let them be relegated to the Grievance redressal committee. Now, my lord, this honorable court came to the conclusion that since it was filed on 18th, and you kept it pending for 5 years,
Okay.
not decided. Now, my lord, it will not be proper on our part, the honorable court's part, my lord, to send back them to the Grievance redressal committee.
Fine.
Now, my lord, the fact remains that, my lord, it was not pending for 5 years. And that is creating little problem for, my lord, the committee, because now, my lord, that observation, it goes, my lord. Let it be, my lord, because that is creating a lot of problem, because the entire blame is coming on the GNRC that having filed the year you have not disposed of, and you have kept pending and all that. my lord.
Asked to keep it
Huh?
abeyance. In fact, contractor.
And my lord, I have annexed a copy of that, my lord. They asked me, lord, not to proceed with.
Fine.
That I have annexed with, my lord, yeah,
201.
201. So, my lord, if that observation goes,
Now then,
this is basically, my lord, that is my my lord,
so if
because
you
this
want
was the
this,
new point.
only this observation will go.
And second
But
point
and not on merit.
Point is Anup trade.
And second point is, my lord, that Anup trade, the judgment in Anup trade basically covers this case, my lord,
No.
not the cover, but the
any.
not the any. No, but still then,
The learned single judges, this division bench has clearly distinguished this case.
Huh.
However, the present is one not a case which involve any exercise of reassessment of rate. The original rate quoted by the responding contractor was converted to per metric ton and so and so. The issue involved here is whether the actual distance covered by the transporter was correctly quoted in the tender document. If not, whether the contractor is entitled to claim additional payment for extra distance as derived by the committee constituted by the FCI and more particularly when the finding of the committee were admitted by the FCI. There was no, in the case of the petitioner is not regarding assessment of rate. It was only distance in respect of the
In
distance,
Anup-
how much distance he has covered.
In Anup trade was similar position
No,
was there.
Anup trade was altogether different.
Here also the rate quoted was not per kilometer per quintal per kilometer. Here also the rate
Division bench
was
of the Anup case observed the based on the rate quoted that the court may not indulge in reassessment of the rate. It was altogether different.
Page 168.
168.
No, page.
In Anup trade, if your lordship kindly take page 168, my lord.
Yes,
Page 1,
Page 168 in Anup trade.
yes.
para 10.
Para 10. My lord, so far the judgment rendered in so and so is concerned, there is no doubt that rate quoted was rupees 11.41 per kilometer per metric ton per kilometer. In such circumstances, in regard to the kilometers measured by the committee, only the rate was to be calculated. So far as the case in hand is concerned, as notice above, rate quoted by the contractor is not per metric ton per kilometer, rather rupees 2759 per metric ton for the entire distance, that is 292 kilometers. So that the distinction between any trade and Anup trade was that there they may not quoted a rate not per metric ton per kilometer, they quoted a rate for the entire distance per metric ton.
In this case,
Yes.
also they have quoted entire distance
In this case also, my lord, they have quoted the rate
for entire distance.
for entire distance.
Yes,
That is how this connected is applicable.
yes.
Till now, we have stated it.
That's, my lord, because of these facts, my lord, my lord, our submission is that Anup trade will my lord applicable in the facts and circumstances of the present case, not the my lord any trade.
So in the year 2018, this contractor has moved and representation and you responded to it in the year 2021.
So GST was not aware.
My lord, my lord, the representation, that was my lord, our case here, my lord, we have given certain documents and made a statement that my lord, when my lord, the affidavits were exchanged,
Essentially, you have filed this review petition being agreed with the observation made by the learned single judge that the grievance redressal committee has took 5 years time and has not decided our case. That this is what your grievance is. And what about this application? This
App-
page number,
application, my lord, I have
this
annexed
is the application of the this page number 196 is the application.
196 is the my lord application.
Is the application filed by the
Application, my lord,
contractor?
filed by, my lord, now this
Is
application
the
was,
application filed by the
yes,
contractor?
yes.
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 And this application,
This application was filed, they say that it was on 3/5. Date is not there, my lord, but some signature is there down below in 196, your lordship will find.
yes,
Now, when the, my lord, in the writ petition, they took a stand that we file a representation,
in
then my
the
lord,
2000,
in 2018. That is their case. Now, in reply that we said that it is pending. Now, in the, I'll come to it. In the affidavit reply, they say that the matter has been already rejected and disposed of.
that is a wrong
Then, my lord,
That is a wrong statement.
then, my lord, in that situation, the counsel who is appearing for the, my lord, the FCI he wrote to them that this is the situation, what you have did with that, you kindly let us know. Then, my lord, they said that we don't have any copy or anything, so you kindly send a copy. He sent a copy to them. Then they have initiated the entire matter. Your lordship will find receipt from advocate GM so and so through so and so 27. Then they have proceeded with the matter. Ultimately, your lordship will find page 200, my lord.
Yes,
Journal of the sort.
Then terabyte comment was sought on 5/2/2021
From.
why,
on the representation
on the
From the-
representation dated?
dated, my lord, yeah, 3/5 2018.
2018.
Regional.
3/5/2018, they say that that is the representation.
Yes.
When the copy was sent by the council, then we not the
Where is your assertion that no such representation was filed by them before the grievance redressal committee?
my lord, your lordship will kind, huh?
Our statement.
Page 10, my lord, will kindly come.
Page,
10 of the review petition, ma'am.
review petition, what you have stated that no such representation was in received by the grievance redressal committee.
Para 18, ma'am.
Para 18, yes.
May I clarify? May I clarify? In the review petition, paragraph 18 and 19, my lord, they have stated that this petition was never filed before that,
Yes,
my lord. Now, if your lordship kindly turns to page 54, my lord, the pleadings in my writ petition,
54.
54 ma'am,
Yeah,
of the review petition,
yes,
para 14, my lord,
para 14.
para 14.
Yes,
Para 14, I'm skipping the first part, my lord, second at page, first few lines, my lord. Second line from the bottom, my lord.
yes,
There exists a zonal grievance redressal cell committee of the respondent authorities, and accordingly, the petitioner submitted an application before the committee raising all the aforesaid issues. This is the document, my lord, 3/5/2018, that your lordship finds at page 78, my lord.
yes,
There is a seal at the bottom, my lord. Page 78, it's a letter before the zonal
78.
8, my lord. There's a seal at the bottom. I have got the original with me, my lord. It's a seal of the zonal office, my lord.
I don't know.
Yes,
How clear it is, I do not know, my lord, in your lordship's copy, my lord. I have got the original. Now, my lord, before going to the original, my lord, lordship will look at the response file in the writ petition, my lord.
It was filed by the regional.
yes, in response to this
In response to this para, lordship turns to page 100, my lord.
para number.
Para 13, my lord, of the affidavit of opposition.
No, this in response to para number 17.
Para number 14, my lord. Para 14 of the writ petition.
No, 17 or 14?
14, my lord. Page 54.
14,
Yes,
14.
14.
Para
yeah,
14, my lord. Lordship turns to page 100.
100.
The affidavit starts at page 94, my lord. Page 100.
Yes, 94, yeah,
Yes, my lord. It starts at page 94, page 100, para 13.
para 13.
That with regard to the statements made in para 14 of the writ petition, I say that the petitioner had approached the zonal redressal committee, write their application so and so, as stated by the petitioner. Then in bold it is written, my lord. The said application is pending before the grievance redressal cell.
Sir, I have already stated before, my lord.
It is absolutely contrary, my
And then my lord will kindly see 115, page 115
Too much.
of their affidavit. Page 115, para 9.
Yes,
Exactly, my lord.
With regard to the so and so, I say that from the statements made there, it is clear that representation submitted by the petitioner before the GRC is not pending.
Exactly.
Page stated by the respondent, but the same has been rejected on the ground that the petitioner has quoted a rate for the entire distance and not as per metric basis. Now, my lord,
That is
first
my
of all, you
interpretation, my lord.
clarify
no,
that
now,
in the affidavit, counter affidavit, you yourself has said yes, representation was there and that is
no,
pending.
true, my lord, true, my lord.
Then And now you are filing a contrary affidavit here.
No, my lord, what happened in that case, my lord, then they.
Deserve to be dismissed with cause, sir.
Exactly. My lord, you might have-
No, you can't take the different stance at different point of time.
My lord,
Required to be.
my lord, if I may
Or either,
allowed to submit.
either this
a
first
affidavit.
affidavit is false or the second
second one is
affidavit is false.
No, second affidavit filed by them, my lord.
No. Second affidavit along with this review petition.
What happened, my lord, if I
The
may?
person, either the person who has filed this earlier affidavit has filed a false affidavit, or the person now who has filed this affidavit with
First
review application
affidavit,
is a false
The
affidavit.
first affidavit was filed by the regional office, my lord.
Same officer,
Sorry,
same officer has filed it, my lord.
Same.
Same officer, my lord. The person is different, same rank, my lord.
The rank may be same. my lord.
Same rank,
It
my
can
lord.
be
How
different.
it says
So
reversion
now
office.
you can't say,
I want to clear the position, my lord. The first affidavit was filed by the regional office, then they are against my affidavit office, and they have filed the affidavit.
then
reply.
how they have
reply
filed this
say-
affidavit? How they have filed this affidavit that they are in receipt of this and that is pending? How they have filed this affidavit?
That fact is there, my lord. My lord, I'm not saying
No,
that fact
we
is
are not
not.
going to entertain all this.
That fact is there.
No, you can't come.
Whatever, my lord,
Any day you come and
whatever,
say that
whatever
affidavit
there
was
in record,
false.
my lord, I can't improve, my lord. Whatever there in record, I can't improve.
Only thing is that they said to keep it in abeyance, that's why.
But my lord, after my lord, this, their reply, then he wrote to the, yeah, that what happened actually. Then my lord, all the facts then came up, my lord.
Fine.
Then they said that no, it was not pending, it was on 21st, they have taken up.
And
The
they-
affidavit
Notice
filed
was
in
given,
the
this
petition,
is
my
the
lord.
fact.
and they said.
The affidavits filed in the report proceeding, my lord, in none of them has stand is taken that this was never filed, my lord. And lordship sees page 17 of the review petition. This present affidavit is filed by the Assistant General Manager Contract of the FCI at the regional office. Same rank officer, my lord, page 94. I say so and so, Assistant General Manager Contract, FCI regional office. Same rank. The person may be different, my lord.
Look here,
Obliging.
this review petition is filed on behalf of the applicants seeking review of the judgment and order dated 9/8/2023 passed by this court in writ appeal number 26/2023. In the review petition, the petitioner has raised, the petitioner has essentially raised a grievance that the division bench has erred in observing that the grievance redressal committee, to whom the respondent moved for ventilating its grievances, raising claim for payment of excess distance, has not decided the claim even though a period of 5 years has been passed. Full stop. It is contended that as a matter of fact, though the respondent in the writ petition has claimed that he has moved and representation before the grievance redressal committee on 3/5/2018, but as a matter of fact, no such representation was filed by the respondent in May 2018, and the representation, and as a matter of fact, the copy of the representation was forwarded by the counsel for the review petitioners to the authorities concerned, who in turn has informed that no such representation is pending. Then pursuant to the communication sent by the counsel for the petitioner, a notice was issued to the respondent to appear before the grievance redressal committee, but the respondent has not appeared before the said committee on the premise that the writ petition filed by him is pending. Full stop. filed by it is pending. Learned counsel for the review petitioner has therefore submitted that the division bench has erred in making the observation that the grievance redressal committee has not decided the representation of the representation filed by the appellant, though a period of 5 years has passed. So it is contended that if the said observation of the division bench goes, then the matter is required to be sent to the grievance redressal committee to decide the representation filed by the respondent. Will stop. It is therefore prayed that that the impugned order may kindly be reviewed. Will stop. For contrast, learned counsel for the applicant for the respondent has invited our attention towards para number 14 of the writ petition filed by the respondent, wherein it is specifically stated, it is specifically averred that the application that the applicant has approached the grievance redressal committee by filing a representation dated 3/5/2018, and the review petitioners in their counter affidavit in para number 13 has clearly admitted that the appellant, that the respondent has filed an application before the grievance redressal committee, and the said application is pending before the grievance redressal committee. It is contended by the learned counsel for the appellant that in view of the clear admission made by the appellants, made by the review petitioners in their counter affidavit to the writ petition, the contention raised by the counsel for the review petitioner that no such application was filed by the respondent before the grievance redressal committee in the year 2018 is patently is incorrect, and on this ground, on this ground, the impugned order cannot be reviewed. Full stop. Having heard the learned counsel for the parties, and after taking into consideration the specific averment made by the respondent in the writ petition regarding filing of representation before the grievance redressal committee, and the specific admission on the part of the review petitioner in counter affidavit in para number 13 that the representation before the grievance redressal committee was filed by the respondent and the same is pending. We don't find any case for a review of the impugned judgment, hence the review application is dismissed.
Butterfly.
Review petition is dismissed.
The contempt, my lord. Contempt, my lord.
It may be taken up.
Contempt will go to the regular bench.
Right.
Contempt, contempt में order कर देना, the contempt will be listed before the regular bench.
Obliged. I'll take back the original one.
Yeah.
Item 3.
May I please? My lord, in this case, my lord, the petitioner was applied for the post of compassion ground, my lord.
Please try to understand that the court has the single judge as well as the division bench has non-suited you, has non-suited you on the ground that you approached the court with a delay of 6 years. And now you are relying on a case of the Supreme Court wherein they The Supreme Court has said that the authority is concerned and delayed the matter. There was no delay on the part of the petitioner to approach the court. So this is a basic difference. And the order seems to be passed under this powers under Article 142 and not under Article 141, sir. That is very clear.
My lord,
In the peculiar facts and circumstances of the case.
yes,
This is what the observation of the of the Honorable Supreme Court.
Supreme Court is. And my lord, what happened, my lord, this, in Annex 12, annexed one order. Out of the same impugn minors, my lord.
But ultimately, the fact remains that you have approached the court after 6 years and now almost 12 years have passed. So there is no question of
My lord, in other cases also, my lord, this honorable court given direction for consideration. I'm not seeking for direction for appointment, my lord, only for consideration by the DLC. my lord.
nothing, like, sir, at this stage. It's very
This is a review, my lord. Scope is limited, my lord.
And out of same impugn order, my lord, in 2023, another case was there, my lord, page number 110.
That has been taken into consideration by the learned single judge as well as the division bench also.
That
So again, on the-
page 110, my lord, this is the judgment, my lord, of this honorable court out of the same impugn order in case of another candidate, my lord, that I could not produce, my lord. Out of same impugn order, another candidate, my lord, this honorable court directed, my lord, honorable single judge directed, my lord.
Therefore, in the peculiar facts and the circumstances of the case, keeping the larger question open, that's all. This is what the observation of the learned single judge seems to be judgment under Article 142 and not in 141
No, this honorable court,
of the Supreme Court on which you are placing reliance can now solve this review petition only on the ground case. And now the Supreme Court has ruled this, therefore, please grant me the relief. This is
another,
what you are-
another case, my lord, I have annexed my judgment, page number 110. Of the single bench of this honorable court, my lord.
Fine.
Where, my lord,
And this
out of the same
this
impugn order.
Supreme Court judgment was very much there when this appeal was dismissed.
That was,
You are not relied upon.
that was not placed at the time of appeal, my lord.
Now you became wiser, therefore only. Anything else?
My humble submission, my lord, the direction to the DLC, my lord, for placing the case, my lord, only for consideration.
No, after this 10 years, we are not. Okay. This review petition is filed by the petitioner seeking review of the order dated 18/9/2023. Judgment and order dated 18/9/2023 passed by this court in writ appeal number 333/2023, whereby the writ appeal filed by the appellant has been dismissed. Full stop. The appellant has approached this court by way of filing appeal, by way of filing a writ appeal, seeking, by filing writ
petition.
petition number
2575,
2575
2023.
2023 with the direction to with a prayer to issue direction to the respondents to provide compensate appointment to him on account of death of his father in the year 2012 while
13,
serving, 13,
2013.
while serving as a government servant. Full stop. The learned single judge has dismissed the writ petition on the ground that the review petitioner has approached the court after a delay of around 6 years. Full stop. The division bench of this court, while judgment and order dated 18/9/2023 has affirmed the order passed by the learned single judge while relying on the decisions of the Honorable Supreme Court rendered in Umesh Kumar Nagpal versus State of Haryana, 1994, 4 SCC 138. As well as so and so 1998. Full stop. Learned counsel appearing for the review petitioner has submitted that in identical that the single bench of this court in writ petition number 495 of 2023 decided on 4/8/2023 has disposed of a writ petition of a petitioner seeking compassionate appointment while giving a direction to the respondents to consider the application for compassionate appointment afresh in terms of clause 15 of the OM number 16/2015. It contended that a similar direction is ought to be issued in the case of the review petitioner. Stop. Having gone through the having gone through the judgment passed by the single judge as well as the division bench of this court, we find that no such argument was raised before raised by the review petitioner at the time of hearing of the writ petition as well as the writ appeal. Full stop. Moreover, the court has non-suited the review petitioner on the ground of delay in approaching the court. Hence, we don't find any case for a review. The order dated so and so as by this court in writ appeal number 22, review petition is dismissed.
All right.
Thank you.